We finally made it into the point where we always wanted to get to, the trial. That's what everybody understands is the make or break moment in any case. And I have to walk you through this slowly because it's the climax of everything that we put our careers to as trial attorneys. It's not about the Hollywood lights. It's not about the final outcome. It's about the process that gets us to a point where we are able to defend somebody's freedom and reputation in a courtroom full of people. The drama is already built in. I'm going to tell you real world stories and how it really feels to sit in that chair, to have to make those objections, to select the jurors, and to try to keep your cool in the face of chaos on this edition of the Lawyer's Lounge, the lead up to the jury trial. I'm attorney Keith Johnson. Welcome in. So everything starts before the trial begins, the lead up to trial. After we have exhausted all the plea negotiations, there's a feeling among veteran attorneys that this case is headed right towards a breaking point where we've tried to negotiate the case. I've explained the consequences to my client, and now the decision has been made to put it all on the line. And as a defense attorney, even as a prosecutor, those days leading up to trial are very filled with anxiety. They're filled with preparation. And I have a routine at this point in time because I've been doing it for almost 20 years. But those early days, it was a little bit of touch and go, trial and error to see how was the best way to prepare for this big event. I'll be honest, even in year 17, I get so nervous before a trial. I don't sleep that well. I don't really eat a lot. Win or lose. And we win a lot because we prepare a lot. But win or lose, I don't have a good night's sleep during trial. So as we get to the days leading up to trial, everything comes into focus. You're going back over the discovery that you might have looked at a few months ago. You're interviewing the witnesses because you want to make sure that there's no stone left unturned. And as you prepare, my goal is to always know the case like the back of my hand. So you want to have that deep knowledge when you're preparing for a trial. On all your cases, you have a surface level knowledge. You know the facts of the case. You know what the witnesses say. You know what the video says. But in trial, you want to almost be able to recite that police report. Because when you're asking the questions of the witness, you may not have time to flip through and find the exact sentence that just contradicted what they said. And so those days leading up to trial are when you do the work, and when you get into the courtroom, that's when you show your work. Think about it. It's a profession where people can come in and watch you in the office, so to speak, because the courtroom is an extension of my office, just like the jails are, because of the nature of being a criminal defense attorney. But I've always found, just like in sports, if you prepare, it can settle your nerves a little bit. And so when you get to the morning of trial, you've already done your jury charges, you've already met with your client for the last time before trial. And I'll give you a little tidbit. Because jurors look at your client during the trial process, we want them to look as good as possible. I talk to my client about what they're going to wear, what their body language should be. And if my client's in jail and they have not been granted bond, then we find clothes for them to wear. I want them to look nice. I don't want them to look like a criminal when they're sitting over there and they're being judged, because that's what's happening from the moment that the jury walks in to the courtroom. And so after you make those final preparations, you have to be ready. I usually have a talk with God. I tell him about my fears. I tell him about the things that I'm concerned about. But ultimately, when I walk into that courtroom, it has to be full speed ahead. It can't be any second guessing, because it's so difficult to control everything that you realize that you can't control everything. That's the true secret of all of this is that you focus on what you can affect. You focus on what's within your grasp. You have to be nimble and able to anticipate things that are going to maybe be off, things that are going to pop up. And in every trial, there's something that does not happen in the way that you envisioned it. So it's about keeping your cool and keeping the client calm as you walk into an unknown situation. So when I walk through those doors on that Monday morning with my trial notebook that I've been working on for months, I know that when I walk out later in that week after the jury verdict, that I have to be able to look myself in the mirror and know that I did my very best. It's a tremendous challenge, but it's a worthy cause. So as we get into that Monday morning, we have to first pick jurors. And you may wonder, where do the jurors come from? Well, jurors are pulled from the state voting system, from the state driver's license system. It's a broad range of how they find people. Honestly, I've never been selected for jury duty. Now, I have some conspiracy theories about that. I don't think I would get picked, to be honest with you, because a lot of lawyers don't want a lawyer on the jury because they feel like the lawyer is going to take over back there when they're talking about the case and that the other jurors are going to defer to that person. But I do find it interesting that I have never received a jury summons since I got back from law school in 2008. Hopefully that changes. I would love to be a fly on the wall. I would love to know what is going on and what they talk about. But the jurors are there to tell the truth. The process is called voir dire. It's a beautiful French word that means to speak the truth. So essentially, as the attorneys, we are trying to ask questions of the jurors to determine, do they have any biases? Of course they do. Everybody does. But are those biases going to affect their ability to be fair and impartial? Can they give your client a fair shake? An old lawyer told me some great advice. He says, while lawyers are picking jurors, the jurors are picking a lawyer. The jurors are watching us from the time that they come into the courtroom in numerical order, and they're looking at us. They're looking at how we carry ourselves, how we interact with the judge, all those intangible things. And I'm looking at them. I'm trying to figure out facial expressions and body language. I want to know what they think about the charges. So when the judge is reading off the indictment to let the jurors know what kind of case this is, I am looking for the reactions. I'm looking for the faces being squinted. I'm looking for the eyes cutting at my client and the scowls. Because this is about picking the right 12 people to determine a life. Each side has strikes or ways that we can keep certain jurors off the jury. Here in Georgia, on felony cases, each side gets 9 strikes. That means we can keep off 9 people out of maybe a panel of 65 people. We can keep off 9 people. The prosecution has 9 strikes. And the only caveat is that we can't use strikes based off of race, gender, religion, and all those reasons that people use to discriminate. But I'll be honest, I'm looking to strike people. I feel like if I don't use all my strikes, I haven't served my client well. And it's not to be negative about people, but I do know human nature, and I do know that I represent people who are accused of very serious crimes, especially when we get to jury trials. A lot of the lower level cases are resolved without a jury trial. So when you are hired on a murder case, or when you're hired on a very serious financial crime case, you anticipate that it's going to be a jury trial. But I need people who are going to give my client the benefit of the doubt, not just because that's what I want, but because that's what the Constitution requires. And so I am constantly, when I'm asking questions, asking about, what do you believe the burden of proof means? Because the burden of proof means that the state has to prove their case beyond a reasonable doubt. They can't just say, well, maybe he did it. Well, probably he was involved. It has to be beyond a reasonable doubt. We believe this and we have a reason for it. So from the very beginning, I'm planting a seed that the state or the federal government in a federal trial has to prove their case beyond a reasonable doubt. And I'm looking for people who disagree with that. Once again, I'm looking for people to exclude from the jury because I want to narrow that down. I'm looking for those people who maybe haven't lived a squeaky clean life all the time, or may know some people who've gotten into the system and know that the system can be very brutal. While we can't talk about punishment, it's an underlying tone in all of this because we're all adults and we all know that if you're convicted after a jury trial, then that's a big deal. Then that means that your client is likely to be sentenced to a significant amount of time in prison. And so the jurors get a chance to tell us a little bit about themselves, and I love it. They stand up and they talk about their age, their profession, their marital status, any civic organization. So it gives us a window into what they're like, but it's really just a snapshot. This is all based on gut instincts because we're selecting people who we want to be fair and impartial. But ultimately, it's up to the attorneys to present their cases in the most effective way. And so once we get a jury, then we usually take a little bit of a break to allow the attorneys to get their thoughts together. Because at that point in time, the trial has not started yet. The trial process has started, but the trial has not started. I've seen cases where people decide to plead guilty after they select that jury. I've been in places where the jury was selected and I thought I was cooked because the jury didn't look anything like me or my client, and they didn't have the warm and fuzzy feeling. Depending on the community that you're in, the jury panel draws from a broad selection of the community. And so you hope to get the diversity that you need in order to get a fair outcome. But that's not always the case. We don't live in a utopian world where everything's going to go according to how we want it to go. But you have to be prepared to present the case as forcefully, regardless of who is on a jury. And so after you come back from a brief break, you start the trial, the opening statement. And the opening statement is your first opportunity to tell the jury a little bit about your case. The prosecution goes first because they have the burden of proof. They always go first. I don't like it all the time, but that's part of the process. I'm taking notes. I want he or she to oversell their case. I want them to promise the world. I want them to say that this is going to be an easy decision, that is clearly guilt involved. Because I know if I'm sitting in that chair, it's because there's some gray area in this case. I don't ever advise a client just to go to trial because we're going to see what happens. That'd be irresponsible and unethical. And so if the prosecutor is making this out to be one of the easiest cases that a jury will hear or one of the most clear-cut cases, that plays right into my hands because I know by the end of the trial, when we're doing our closing arguments, I'm going to have an opportunity to remind the jury about exactly what this prosecutor promised and why the evidence didn't line up with the promise that he made. On the flip side, when I get up there, it depends on the case. If I have a case where I feel like we're fighting an uphill battle, like a true uphill battle, where there might be some DNA involved, or where there might be a statement made by my client before I got involved that I wish he or she wouldn't have made, I put that out there from the very beginning. I don't want the jury to be surprised by a witness. I want them to know the weak parts of my case first. I want to be able to tell them and to give them some context to that. Because opening statements are different from closing arguments. And so when I'm up there, I have to be very mindful that this is not arguments. I am preparing the jury for what they are about to hear. It's a preview of the evidence. This is what I expect the evidence to show. There are some cases when it's a gray area, when it's a lot of inferences. There may be no direct eyewitness. I'm a little bit more coy in my opening statement. I don't lay it all out. I just say something to the effect of, you're going to see the lack of evidence in this case, and it will become readily apparent that my client is not guilty of a single thing in this case. So you have to have a few things in your bag of tricks, to be honest with you. You have to be able to know what the tenor of the case is and then react suddenly, spontaneously, because that's the key thing that I want you to take away from the jury trial series, which is you prepare, you have a plan, but you have to react. You have to go with your gut instinct. You have to go with the experience that you have. And during the opening statements, you look at the jury, you look at their body language, you look at how locked in they are. I can tell who's taking notes. I can tell who is intently watching and who's cutting their eyes at my client. All those things are important. Now, I can't do anything about it from the standpoint of removing them from the jury. They're locked in now. We got to deal with them. But I know that I may have some people on my side. I may have some people nodding their heads. Or conversely, I may have some people who seem skeptical and are going to be a problem. And after the opening statement, the prosecutors go first. Once again, they have the burden of proof. And keep this in mind, the defendant never has a burden of proof. I've been successful on many cases where we didn't present any evidence. We rested our case after the prosecutors rested their case. But a lot of times, if you have evidence, you want to present that, but you don't have to make that decision until the end. That's the advantage that the defense has. We can see exactly what's going on, see the lay of the land, and then make a decision. Hey, I think you need to testify and tell your side, or no, I don't think you need to go up there and risk getting tied up with these questions, getting nervous, showing emotion that you don't need to show. I don't think that they've connected the dots. We're going to bring this home in closing arguments. Those are the conversations that are had towards the end of the trial. But I know what the prosecutor is going to present because I've seen the witnesses. Remember, this is not like on TV where it seems to be a surprise when a witness strolls into the courtroom. The state has to present their witness list to me several days before trial. And so I'm able to narrow down who they're going to call as witnesses, and also I should know what they're going to say because that's how I craft my cross-examination. But I'm not going to get to cross-examination yet. We're going to stick with what's called direct examination. And direct examination is simply put when your witness that you call in the court is on the stand, you're asking that witness questions because they first have to answer questions from the prosecutor, and then they answer cross-examination questions from the defense attorney. So it's not a situation where you can call a witness, ask them your questions, and shield them from the cross-examination questions. I think that's very important because strategically speaking, the lawyer has to determine the pros versus the cons. I might call this eyewitness. They might tell me some good information, but they have a horrible criminal history. Or I might call this officer. He did a pretty good write-up, but his personnel record is very bad. Or he loses his cool on the witness stand because when he's challenged, he takes everything personally. So you have to have a playbook on what you want to do, what you want to achieve. And a lot of veteran prosecutors will go less is more. As a defense attorney, I want to know who the prosecutor is because that helps us determine the personality and how the case is going to be presented. You have some prosecutors who are very, very aggressive. They get boisterous. Like I said, they even maybe overpromise. So the more amped up a prosecutor gets, the more calm I get. The more that I know I have to be cool, calm, and collected because that jury is watching and the judge is watching as well. Some prosecutors are mousy. They don't have a lot of confidence. They might be new. They might not be comfortable in the setting. They might be a little intimidated. So at that point in time, you have to know how to react to that as well. You have to go in there like you own the courtroom because it's an extension of our office, like I said. And then you have those younger prosecutors, the ones who are hungry. They want this win because it's a big win against a known person, a known attorney even. You have to be able to sift through all the ego that comes with it because trial lawyers do have egos. But you have to know the opponent. Just like when I play football, when you know the opponent, you know what they're more likely to do. You know what they're likely to come to the table with, so to speak. And so as that witness is on the stand, I'm taking notes because I want to make sure that I'm listening, not just ready to ask the questions that I prepared last week. So part of that is having notepad there, taking down those notes, consulting with my client, making sure that I'm making eye contact with that witness and I'm looking at that jury as that witness is testifying. To me, that's very important. That's very informative. You have to remain in the moment. And you have to make sure that the client is calm because that client is going to be hearing things about themselves all week that are not flattering. Now, keep this in mind. How many times have you actually had to sit down and hear somebody talking bad about you? Probably not too often. And if you have, you probably had a response, right? You didn't just sit there and take it. You might have left the room. You might have defended yourself. You might have tried to talk to them about it. But how many times have you just had to sit down and listen to somebody talking crazy about you? And I tell people, man, you got to have a poker face. You have to be able to sit there and understand that this jury is watching when you scratch your nose. They're watching when you look down when they show the crime scene photos. They're watching when the officer says, that's him, and they point. Literally, I've had prosecutors walk over to the defense table, and I hate this, man. Stay on your side, bro. Don't come over here, man. But it's allowable. You know, I have to keep the professional thing going. But I tell my client, they're going to walk over there and they're going to point at you. This man is dangerous. You need to hold him accountable. And all the rest of the theatrics. That's just part of the playbook. So I try to prepare them for that. We call it the poker face because you don't want anything to be taken out of context. And that's the whole thing. And it's hard to do. I have to even catch myself when I make an objection to just state the objection, not be too argumentative, and just let the judge make the ruling. Sometimes the judge rules for you. Sometimes the judge rules against you. But I don't want the prosecutor telling the story on direct examination. So we'll go a little bit deeper into the weeds. Essentially, the prosecutor can't put words in their witness's mouth because they're direct examination. As a defense attorney or the person that's cross-examining the witness, I can say things like, isn't it true? Wouldn't you agree that? And then I can say what my question is. Prosecutors have to ask what's referred to as open-ended questions. Tell us what happened on that night. And then what happened? And then what did you see? So if the prosecutor starts trying to pull information out of the witness, I know I got him. I know that the witness is not testifying in the same way that the prosecutor thought they were going to testify or how they practiced a couple weeks ago. And so I have to be quick to make that objection. And that might be the hardest thing about being a trial attorney is always being on. That's the mentally exhausting part when you get home, is that for 6 or 7 hours, you're sitting at that table. You have to be locked in. You have to listen. You can't daydream. You can't kind of be in the midst but not really paying attention. And here's why. Because if you don't object at the moment that the question is asked, then you can't come back after you've lost the case and say, well, judge, you shouldn't have allowed them to ask that question. You shouldn't have allowed that witness to talk about my client's criminal history. It's called a contemporaneous objection. So that means that if I don't stand up in those 1 to 2 seconds, My client's rights to appeal an unfair process can be forever waived. Forever. And I'm talking about a life sentence. So that's what adds to the stress and the anxiety, because you have to know your case and know the rules well enough to know when they're being violated. So you have to make those objections, even if the objection is overruled, because you're preserving it. You objected at the moment. The judge didn't agree, but guess what? We can come back behind the scenes and appeal it. And then an appellate judge or a court of appeals or a Supreme Court judge can see if the trial judge really applied the law correctly. And I'm sure it's hard being a trial judge for a jury trial, because you also have to be on. And every judge ain't on, all of them ain't on. I've had judges be nodding off up there. I've had judges on their laptops. But I've also had some really good judges who pay attention to the case, who are locked in, who are taking notes, and can really recite what each witness said in depth. Those are the judges who were trial lawyers at one point in time, so they understand what the process is like. So when the prosecutor says something or does something that is out of the rules of evidence, I am duty bound to make that objection. Sometimes I win the objection. If I win it, it's sustained. That means you cannot answer that question. The jury cannot consider that answer. If it's overruled, well, I didn't win it. I sit down and I keep moving. But that's part of the process of being locked in, especially when the other side has the witness on the witness stand. My job as the defense attorney is to test the reliability of the evidence. That's the whole point of all of this. I get the question a lot. Do you represent guilty people? Or I get the question, if somebody's guilty, how can you stomach representing them? And I answer it as honestly as I can. I have morals. I have my own personal private morals. I want to do the right thing. I want my kids to do the right thing. But I know everybody doesn't always do the right thing. And I know that sometimes things are complicated. And I also know that we have a system in place that is designed to test the evidence before we take away somebody's liberty. And I believe in that above anything else, because the way that our system is designed, the founders would have rather a guilty person walk free than an innocent person have their life taken away and their freedom taken away. That was the decision that they made. That's why you're presumed to be innocent. That's why I talk about that all the time, about the rush to judgment, because my job as a defense attorney is to test the reliability of the evidence. And it cannot work. The system cannot function if people are not able to have their good name when they walk in the court and keep that good name unless the evidence proves that they've committed a crime. It's just that simple. Now let's get to cross-examination. That's my favorite part. Well, maybe I lied. I think closing argument is my favorite part. But cross-examination is a close second, because you're able to pick apart the prosecution's case at your own pace. For example, you have to be able to do it in a few different ways, because it's verbal warfare, literally. I mean, sometimes I have a witness who is docile, or maybe even a minor. Those are tough. You want to be controlled as a defense attorney, right? You don't want to go up there and, make the jury actually have more compassion for the docile person because you're berating them. You're beating them down, and you might be thinking that you are doing something big. I've seen lawyers who are thinking that they are winning. They are boisterous, they're talking loud, but the jury is over there silently upset. They know when too much is too much. And you have to keep in mind that jurors are not in court every day like we are as legal professionals. So this is all shocking. This is all like, oh my God, I can't believe that person started crying on the witness stand. Meanwhile, I'm thinking, oh, come on, stop with the act. But that's part of it. And so depending on the kind of witness that you have determines the strategy. I had a trial recently where I had a hostile witness. I mean hostile. And It was the victim in the case. And the fella was not answering just basic questions. And I asked the court for permission to treat him like a hostile witness. That was granted. So now I'm able to really, really be more aggressive than I normally would like to be. But I had to because he wasn't answering my questions. He was trying to ask me questions. And I had to take control of the situation as best I can. And for some witnesses, you can't control them. It's like a wild horse. You can't put a saddle on a wild horse. So now what you do is you try to show how unreasonable they are. When they get elevated, I get more calm because I will be penalizing my client if I lose control. And I've seen attorneys fall into that trap where it becomes a me versus you thing. You have to always keep in mind you're representing this person sitting across the room at that table that is watching you perform and representing them in the most trying time of their life, literally. Then you have witnesses who are experts. These are the tough witnesses. These are the people who are the investigators, the chemists who test the DNA, the crime scene technicians, the counselors who are used to testifying, who have testified in trials for many years. So you're going up against another legal professional. And you just want to score points, just a few points here or there, so that you can sum it all up at the end. Because those are witnesses who you're not going to get to backtrack. You're not going to get to agree with you. Now, you can show their unreasonableness, but it has to be based on fact and evidence, whether it's showing them what they typed in their report or playing a statement that contradicts what they have said their observations are. It has to be based on facts because, once again, these are witnesses who the cross-examination won't always look like a knockout. It won't always look like them agreeing with you. It won't always look like them being stunned and not having anything to say. It may look like a subtle point. And then I sit down because you never ask a question that you don't know the answer to. That's a cardinal sin as a trial attorney. Why? Why would you not ask a question you don't know the answer to? Well, what if they say something that's totally unexpected? And now you've compromised your client's defense. We don't want that. That would be reckless. I've seen some recklessness. All right, so this is how I practice law. It's not how everybody practices law, but this is how I practice law because I want to be as cautious as possible, especially when I'm dealing with these very high-level cases and these very high-level crimes. And so when you get a person on the witness stand, you have to keep in mind that you are not just asking a question, but you have to listen. You have to listen to what they're saying because you may miss something. When I was younger in my career, I had my bullet points and my questions, and I would go line by line. Well, you have to keep in mind that the next question might not always be the appropriate question to ask next. You might miss, if you're looking down, the fact that they squirmed a little bit when you asked them about the timeline. And so if you sense that, if you see that this question didn't get the response that you thought it was going to get, in a good way though, you have to stay there. You have to needle them. You have to make sure that you're making them tell that story again, because the second time is not going to be like the first time. You have to make sure that you are keeping the focus. That's why I talk about staying in the present moment. Because if you're not in the present moment during a trial, you may miss something. But that's a learned skill. That's not something that you're born with. That's not something that really you're taught in law school. You just pick that up along the way if you're paying attention. And when I get a client who is calm and collected, it allows me to really focus in on the case. You have some clients who are really assisting you while you're on cross-examination. They are writing down notes. Hey, did you ask this? Hey, what do you think about this? And I appreciate that. Then you have some clients who literally, I've had trials where they are just over there chilling. I give everybody a pen and some paper. This is your case, and you've selected me to help you with the case. I appreciate that. I respect that. But I have some who are like, whatever you think. And that might sound cool, but that's really heavy too. Because while I know that they're not the legal professionals, you really do feel like, man, I'm in this thing by myself. So on cross-examination, you have to make sure that you have your own handwritten notes, but also the stuff that you are prepared for weeks in advance. And so the point of cross-examination is really to stress their case, to find the weak points and squeeze, like I've always said. Sometimes it can be brief. Sometimes it's prolonged. I've had witnesses on the stand for hours before. Sometimes I may say, Judge, I don't have any questions for this witness. You may say, man, why in the world would you not have a question for the witness? Because I want to signal to that jury that this is an insignificant witness. They don't have any factual knowledge of what happened. That's a gimmick. That's a risk, but it's something that I've done and I've been able to do on multiple occasions when it's appropriate. So after cross-examination, maybe the prosecution comes back and asks a few questions to clear up things. And if they are following up based off of what I just asked, I know I got them. Because I know now we're playing on my side of the football field, basically. We're playing my game. I'm taking them down a rabbit hole because now they're trying to clear up things that are confusing. Because, see, reasonable doubt might not look like the client is innocent. Reasonable doubt might look like, I don't really know what happened, man. I don't know. I don't feel right. He probably was involved, but I don't know. That's a win. That's what we want. It doesn't always look like it's clear because a lot of times it's not clear. And so once we're done with that, the state will rest their case. And now the ultimate decision is made. Do we present witnesses? But more importantly, does my client testify? Because my client has a right to remain silent. It means just what it says. He can sit over there, not say anything, and still win the case. I had 6 trials last year. I was fortunate to win all 6. And I can tell you that in those trials, I didn't have any of my clients testify. None of them. Not one. Because it didn't make sense. Now I've had trials where my client had to testify because I wanted them to get their side of the story out. So it just varies. But that's a conversation that should be had before we get into the courtroom. You should prepare the client for the questions. And I will not put a client on the witness stand if they have a temper, if they have a nervous laugh, if they really just are not able to articulate themselves. Because now that'd be my fault if I put them in that situation. I would rather try to explain it in the closing arguments and put the burden on the state, because that's where the burden lies, than put my client in a position where they've said something, they've gotten flustered, and now that's the last thing that the jury hears. And so whether we present a case or not, it's ultimately up to the attorney, but the client gets the last word. The judge usually asks them a set of questions that they have a right to remain silent, that if they do not wish to speak, that he will instruct the jury not to hold that against them. And there are jury charges that the jury hears and has to apply that lay that out, that this person is presumed to be innocent and they don't have to talk. And you can't say, well, they didn't talk, so they must be guilty. Now, I wasn't born last night. So if you have an allegation from like a young person that you touched them inappropriately, the jury wants to hear what you have to say. They want to hear you say, nah, I didn't do that, and here's why I didn't do that. So there are certain levels of cases where your story needs to come out. And I try to prepare my client. I try to be the prosecutor. I try to get them upset when I'm asking them mock questions to see how they're going to react. Are they going to react with a lot of emotion? Are they going to be matter of fact? Are they going to look me in the eye? All those things that are not necessarily natural, we have to try to prepare. It's not coaching, it's preparing them for something that they've never done in their life. And so after the defense rests their case, then it's ultimately up to the jury. But before we get to that point, we do have closing arguments. And I think I'm going to save closing arguments for the next episode, because closing arguments are where everything comes together. That's what is dramatized. That's what people remember about the O.J. Simpson case. That's what people remember about these high-profile cases, right? I mean, where'd the phrase, if it doesn't fit, you must have quit, come from? It came from the closing argument. It wasn't an opening statement. That was after the cross-examination question of the legend, Johnny Cochran. When he knew that that glove was not going to fit the rheumatoid arthritis hand of his client, O.J. Simpson, he might even known that the glove had been blood-soaked and that it probably had shrinking a little bit. He might have known that. The prosecutor allowed that to happen, allowed him to make that request to the judge, and the judge allowed him to have his client stand up with a latex glove over his hand and then put on a glove that didn't fit. And that was the case. 30 plus years later, that was the case. If it doesn't fit, you must have quit. And so every case has a theme. We tried to develop the theme from the very beginning, but the theme is brought together during a closing argument. But as we reflect on what we talked about, the feeling of being in trial is what I want to leave you with. Very few times in life do you wake up in the morning and know today somebody's life is going to change. Today my life can change, because my life has changed from big cases that I've been associated with. Trial is about knowing that something is about to change, good or bad. There will be a winner and there will be a loser in this case. There will be somebody who will be upset that somebody walked free that they believe should be going to prison, or there may be a loved one who's upset that the relationship with their loved one will never be the same because they'll never hug them again. That's the reality of trial. You have to stay balanced. You try to stay centered, but at the end of the day, it is competition at its highest form. It's a competition for freedom, for lives, and for the minds of strangers. People can come into work, my work, and see me perform. Every trial that I've had, there's a transcript of it. Every word that I've said in the trial, there's a transcript of it from the court reporter. That's a heavy responsibility. That's a heavy burden, but it's worthwhile. I think it's the greatest profession in the world. I think it's the hardest profession in the world, but I know I'm biased. So as we go behind the bar, inside the justice system, you now know more than 99% of people. And I don't say that with any arrogance. I say that with humility, because it's been such a pleasure to talk about these things that lawyers really talk about behind the scenes, right? In the lawyer's lounge. So, as always, the past is behind you. There's nothing that you can do about that. If you must look back on it with thankfulness, with gratefulness, that you overcame things that you might not have thought you would overcome when you were going through it. The future is unknown. It belongs to the good Lord. There's nothing that you can do about worrying about something that hadn't even happened yet. Put your faith in God in the present, right now. That's what the Bible says. Cast your cares on the Lord, for he loves you. He loves you so much. Until next time, salute.